Good morning.
Well, good morning, everybody. Here we go again. We haven't done this before. It is WGL AM. It is Monday, May 4th, and I am joined by Miss Hannah Hill of NAGR. Good morning, Hannah.
Good morning, Bill.
And Mr. Kostas Moros of the Second Amendment Foundation. Kostas, good morning.
Good morning, guys. How are you guys both doing?
We're excited. Maybe today is the day. This is the 5 cases for those of you who actually have not been through this exercise of futility with us before. These are the 5 cases that we are actually watching. Duncan and Gators are both magazine ban cases. Viramontes, NAGR v. Lamont Grant v. Higgins are all assault weapon ban cases. And just to give you an idea, does this seem like Groundhog's Day, guys? This is the number of conferences, and I think last week's slide was all screwed up, so I went into the dockets and counted them myself. Okay, this is the number. This is the 15th conference on Duncan already, and Grant, which is the newcomer to the group, is already on its 9th conference, and worse yet, this is the conference schedule moving forward. We do not have a conference this coming Friday, but we start having them on Thursdays, May 14, 21, and 28, and then a bunch on June as well. And one of the other things, when I was looking at the Supreme Court calendar yesterday, I realized they don't got oral arguments anymore. They are done with all of the oral arguments for at least until summer break. So they should have plenty of time to not only draft opinions, but to get some of these issues resolved. So, Hannah, any predictions today?
Oh, I'm scared to predict, Bill.
Well, we know what the safe money's been on, but eventually that runs out. Kostas, any predictions today?
No, I do note that as of today, Gators Guns will break the record for the most relists. Well, it was Masterpiece Cake Shop had 14 relists before it was granted. So if Gators Guns gets granted after that, it'll be breaking a record.
There we go. All right, that's good. Well, Duncan would break the record too, then, because Duncan's got one.
Duncan's one less than Gators.
Oh, does it? It has one less?
Yeah, because they waited for So
that's only if you count this time, though. Has anybody counted up how many conferences y'all got last time you were before the Supreme Court and added this one?
No, I don't remember. I think this one's gone longer than last time, though.
Well. Yeah, this has been, and listen, I think Snope last year in Ocean State got about a dozen conferences in before we ended up getting rejected on that. So that was a painful experience as well. And we have an orders list, guys. It is up.
How come I can't see it? Lame. Oh, there it is. Yeah. It's loading slow today.
No Duncan, no Lamont.
Oh, well, here we go again then.
Here we go again.
No Gators Guns. No Viramontes.
It appears there's no grants today.
No,
yeah,
I know.
That's common this late in the term. They often no grants.
So we don't have anything on any of our 5 cases today.
Short list today, y'all. As it goes.
Is it a short list? It is a short list. It's only
not much going on.
We got a rehearing denied, mandamus denied. Did you guys happen to ever read the miscellaneous orders that come out on Thursdays and Fridays?
It's a lot of death penalty stuff.
It's a lot of death penalties. That's why I was bringing it up, because, man, you want to talk about a very unceremonious end to a lot of things. When your petition for rehearing on a death penalty case gets denied, you get about a 1-sentence mention on a miscellaneous order like, yep, it's denied. Good luck to you.
Your next appeal is to Jesus.
Your next appeal is to your maker. So hope you do better with that one.
That's probably one of the top reasons I don't think I could be a judge.
You don't think what? Because of the death penalty?
Yeah. I just,
most hey, you pick the right jurisdiction where the jurors hand it down, Hannah. The jurors hand down the sentence, and you just shrug your shoulders.
Look, I can't argue with it on a theoretical basis, but I argue with it a lot of times on the political basis. So there's that.
Well, I will tell you quickly, I used to be a huge proponent of the death penalty, and I'm not against the death penalty, but I did get sick and tired of reading stories about people walking off death row that didn't actually commit the crime. That's a
Yeah,
little
no.
troubling at times. So,
It is very troubling. By the way, there's two other cases. A 922G1 case, Tabor, got rejected.
okay, that was not totally. I mean, it's a 922G1 case, and we're going to talk about that during our morning scramble here in a second, because the court has been laying waste on a lot of those cases. There is a case that I did find coming up. It's Moore v. Kipke. It's an interesting case. It's a petition recently filed. And basically, this is a Wolford v. Lopez do-over in Maryland, because the issue is, did the Court of Appeals err in concluding that Maryland's private building consent rule, which prohibits individuals from carrying firearms into buildings on private property without first obtaining permission from their owner, is unconstitutional? I'm assuming that this case has got GVR written all over it, since it is literally a very similar. I know nothing's quite like that Hawaii vampire rule, but quite similar. Kostas, have you seen this petition at all?
Yeah, it literally asks at the end to hold it for Wolford. So I think I think they know Wolford's probably going to win, but they filed this just in case. Like, if Wolford loses, then they should their case should be reversed too. But we're fine. I'm not worried about this. I think they did it just as a precaution in case we're all wrong about Wolford. But yeah.
Let me ask you this, Kostas, from a strategical standpoint. I'll ask you too, Hannah, from a strategical standpoint, when you got a petition that's ready to go and you got a case that can kind of maybe answer the question, do you think it's a good strategy to, instead of really be begging for review, just beg to get a GVR? A lot less lifting from the Supreme Court.
I think it demonstrates how ridiculously stingy the court has gotten with cert grants, that people are like, just give us a GVR, please. Just give us a GVR. They know it's so hard to stand out when it comes to cert grants, that it's almost smart to ask for a GVR, because maybe the court will do that for you, but they won't do a cert grant in most cases. So,
yeah.
Unless you've got some very technical tax case, in which case, then they'll love your case and you'll get
yeah, exactly. Or if it's something that everyone's pissed off about what the president has done, they'll actually hear that case next week. Yeah. Hannah, what do you think on that?
No, I agree with Kostas, and I would also. I mean, they don't have anything to lose. They know they're not going to get cert, so they might as well try it and see if it works. Has anybody actually seen this work other than? I mean, I think a few of the DOJs have gotten held. Right, for GVRs, perhaps. But as we saw last week, they don't always say yes when GVR is requested. So, I mean, it can't hurt. And sometimes it seems like it's a little bit of an easier lift than a cert grant. So might as well try it.
I agree. I agree with both of you guys on that. For those of you just tuning in, thank you very much. We appreciate it. We have the orders list out. Our 5 usual suspects: Duncan, Gators, Higgins, Grant, and Viramontes. We do not have word on any of them, which means they are going to get rolled. The only good news for Hannah, Kostas, and myself is it get rolled 2 weeks instead of 1 week, so we won't have to do.
We get a week off. Thanks,
Supreme. Get a week off. Yeah. Well, you guys can always have the week off because you're here voluntarily. Okay, so I appreciate y'all being here.
We're getting paid for this. I'm logging out.
You didn't tell Kostas? Oh, I'm sorry. I wasn't supposed to say anything.
Yeah, we'll all start getting paid. Exactly. Yeah.
I was going to call your HR, Bill. I was wondering where my check was.
Yeah. Check's in the mail, Kostas. Check's in the mail, man.
Can I ask y'all a process question real quick?
Yeah, of course you can.
Have you ever seen the Supreme Court hold cases pending a cert grant, past the term? Or are they... Okay.
So I've discussed this with Charles Nichols, who follows this stuff, and he says it can happen. It's rare. I don't know if he's seen it before. They can't hold it for 2 terms, so they can hold it over 1 summer, but not 2 summers. I think is what he explained to me.
Internal rule or something like that.
I'm not sure if it's a rule or a practice, but this is what we explicitly asked for this in our Duncan amicus. We basically said, hey, if you're not going to grant Duncan, then just hold it forever until you do a hardware case. Because
that's right, you did.
Because if they deny it and the mandate issues, people will have to turn in magazines, like that have been protected until now because of the stay orders. So even if they don't want to do Duncan, they should hold it until they do any hardware case, even if it takes years. I don't care. Of course, realistically, they probably will just deny it next month. Unfortunately, the way things are looking.
Here's the California guy. If Duncan were to get rejected and the ruling of the Ninth Circuit stands, and now there is a surrender date where you have to turn in your magazines, what percentage of magazines do you actually think are going to get turned in?
Well, mine will have to because I don't want to get arrested. But
I wasn't asking about yours. We all know
I would
you are a law-abiding.
Actually, I would probably mail them to a friend or something. But what's frustrating? You're right, though. A lot of them won't. And we talked about this in our brief. We said we straight up said a lot of people will refuse to turn them in, and you'll be creating felons. And what's frustrating about this is Kavanaugh said, maybe Kavanaugh will turn out to be wrong, but Kavanaugh said they're going to do a hardware case in the next term or two. Well, we're through one term, but it would be very frustrating if they deny Duncan, people turn in magazines, then a year later they do a hardware case and say, oh, you guys were right the whole time. Well, thanks, guys. Like big help, now that everyone's turned him in, people have been arrested, so that's why we told them hold Duncan indefinitely until you do a hardware case, or just grant Duncan. That'd be ideal.
That would be the easiest solution. And if ever there's a case that deserves a grant, it's Duncan. I've been kind of tracking out that May 14th conference, guys, that's coming up in a couple of weeks, and it's going to be a bloodbath. But again, when I say a bloodbath, there's a ton of petitions, 922 G1 petitions, in instances in which obviously the federal government has asked to waive their response. That was granted. It's getting set for conference right away. These cases are all DOA. And we're going to talk about an interesting case that's coming up in there. Here's another interesting thing. A new petition. We talked about this last week. This is Mislow versus the United States. And I did a little more geeking out. I was thinking about doing a video on it. I don't know if there's enough interesting material there. But this is a person who gets discharged from the military for something that particular offense would not disarm you. But since it resulted in your less than honorable discharge from the military, it then results in in disarmament. This is a case that was on before that, and there seemed to be getting slow played. And lo and behold, I find out that there's already another petition before the United States Supreme Court, case of Zong versus the United States. That case was conferenced back in February, and now it's been punted down the road for a ways. So this is an issue, at least early on, that the United States Supreme Court appears to have mild interest in.
Yeah, we'll see what happens.
So, Hannah, do you understand what the issue is there?
Yeah, but go over it for me again.
Yeah, okay. So let's say that you got caught in the military doing some type of activity, which if you got caught as a private citizen in law enforcement, might get you in trouble, might get you cited, might even get you arrested, but would not, if convicted, result in your disarmament. Okay, it's not a disqualifying offense. However, because it happened while you were engaged in military service, you get kicked out of the military. You get a less than honorable discharge. And those are disqualifying events. And what the issue, so their issue is number one, is there a historical tradition to support that? Number two, the military courts are claiming that they don't have jurisdiction to go back into the records and clean things up. And of course, the former military member saying, of course, you have the ability to do that. So we have some people that have been permanently disarmed coming out of the military for stupid crap. And I'm not saying that the military shouldn't have discharge. I'm not going to tell the military how to run their business, but to have them disarmed in perpetuity is a little overbroad.
Okay, so a couple of things. One, I don't see an obvious GVR for that one based on either of the two gun cases the Supreme Court has taken.
Agreed.
So this is a very left field kind of approach. Second, I mean, the military dynamic is, I mean, aren't there a lot of things that are minor to a civilian that can get you dishonorably discharged and therefore gun prohibited?
Yes, your life. I did not serve, and thank you for everyone out there who did. But yes, no, your life has significant more restrictions on it when you were in the military. And like I say, there are things that you could do as a private citizen that could land you in trouble. You know, you can get a citation, maybe even charged with a crime or something. It's not going to totally upend your
Right.
life, but in the military, it just effectively terminates you. Smoking a joint, right? If you pee dirty while you're in active duty in the military, you're getting chucked out of there. You are getting thrown out.
Right.
Yet a private citizen, especially in a large number of states now, could smoke a joint on a Friday night. Ain't no big deal.
So then the question is then, is the issue here the fact that the original charge was gun related, or is it the fact that the dishonorable discharge is earning them,
Yeah,
the
it's
prohibitor,
because in both of these cases, it literally was the example of one guy in the Navy, one guy in the Air Force going out smoking weed on a weekend and pissing dirty. That's literally what they got thrown out for. And again, I'm not going to second guess the military for throwing them out, because I think we have a pretty damn good military.
No,
So they can
yeah.
just keep doing what they're doing. But should that warrant an individual being disarmed in perpetuity? That's the question.
Yeah.
And we have a historical tradition of doing that.
So the real issue with the law then is that the blanket prohibitor for dishonorable discharge should be revisited.
Bingo. There are certainly some things that you're going to do in the military, violent crimes,
Mhm.
crime, espionage, and things like that, that I have zero problem with people being
Right.
I have zero problem with certain people being just locked up and us throwing the key away. Espionage happens to be one of those. So I have zero issues with disarmament on that. But there are a lot of other things,
Mhm.
nonviolent stuff that you can do in the military that can end up in your less than, because there's a less than honorable discharge and there's a dishonorable discharge. And then there's an honorable discharge. And, one of the three is awesome and the other two, not so much.
And they're not really thinking about that with the classification they give you, are they? They're not when they decide which one you get, when they're giving you the boot, they don't necessarily think about the fact that there's a lifetime gun prohibitor.
No, they can care less. This is the military.
Yeah.
They barely care about you while you're there. They certainly don't care as much about you once you're gone. And that's been one of my criticisms of the VA is, we do a great job of equipping our young men and women when they're actually in service. Once they get out, do we do enough for them that we should? I think it's a
Right.
question.
Right. Well, I mean, and I agree holding them to a higher standard when they're in the military. My best friend is an Army captain. And there's a lot of, there's in the firearms litigation sphere, there's not a whole lot of understanding of the actual dynamic they operate on, especially with the military parallels drawn in the 18 to 20 case, that type of issue. Just because, it's a very different dynamic for an 18-year-old in the military versus an 18-year-old in real life. And it would be wise for anybody litigating that to sit down with somebody and actually hash through that so that the arguments you're making are actually accurate. That's it. So I mean, it's so different. I have a brother in the Navy, same thing.
That's right, you do.
So I mean, but at the same time, the question here is about transition. It's about when you go from being in the military to being a civilian, and how much what you did in the military should impact the rights that you have as a civilian. And I mean, this is a jurisdiction case, really. So maybe the Supreme Court actually is thinking about taking it.
They may be. I would prefer they take a hardware ban case, but
well, if it's not a Second Amendment case, it shouldn't take a slot for us, right?
Yeah, that's right. It doesn't take up doesn't take up the Second Amendment bandwidth. There were a couple of content creators a couple of weeks ago when Gardner got shot out of the sky that were trying to spin it as, hey, this is a good thing. This is a really good thing that Gardner got rejected, because it still keeps that spot open for a more important Second
That's
Amendment.
stupid.
I agree, because who claims that there's actually a spot open for Second Amendment?
No, there's no guarantee. And this year, as we learned, they did 2 cases, so they can do multiple if they want to. They could do 5 if they wanted to. So I've never bought that. We hear this a lot too. So when I do an amicus brief, for example, in a cannabis case, a lot of people get mad because they're like, well, why aren't you prioritizing hardware? It's like, we have like 10 hardware cases at SAF and we do amicus briefs all the time. We're not going to you can't game it. It's not as if the court is like, well, we were going to grant this. We were going to grant Duncan, but they just asked for this marijuana case. So we're going to do that instead. No, they know what they're going to grant and what they have the appetite to grant. And you just do your best to, so Gardner was a very compelling petition. I'm very sad it didn't get granted, and like it's silly to think, oh, it's a good thing it didn't get granted because
Agreed.
now we're going to get a hardware case. You know, maybe we will get a hardware case, but if we do, it'll have nothing to do with Gardner
Bingo.
being denied. Yeah.
Yeah,
I sympathize.
go ahead, Hannah.
Sorry, I sympathize with where they're coming from. I mean, we're all desperately trying to read
Yeah.
patterns and to really what we can't guarantee there is a pattern there in the first place. You're right. The Supreme Court is always going to do what they're going to do.
Right.
And I think even the excuses they give us and their, dissents from denial or statements on denial of cert that we've gotten a couple of times, even those can't be completely relied on. They sound like excuses, and the Supreme Court, the minute those excuses stop making sense, they just do whatever they want to do anyway.
Yep, I agree. I just don't think that the Chief Justice sits down at the beginning of each term and says, all right, guys, I charted it all out. We got enough spot for 2 First Amendment cases this year, 1 Fourth Amendment case, 1 Fifth Amendment case. Of course, we're going to have spots for about 3 on the Commerce Clause because that's a big sucking. I mean, it does not work like that.
And then we have 25 slots for boring cases. As Charles Nichols jokes, the Supreme Court likes complicated cases as long as they affect almost nobody.
Right.
He is right about that.
He's right. Well, and too, I think there is some rationing going on in Chief Justice Roberts' head, but he's rationing controversy, and he doesn't know what's coming down the pike. And there's only so much he's willing to do to rock the boat. So I think that cost benefit analysis is always running, and maybe that's why the strategy is always all over the place with him.
I had one friend who observed that this court is not scared of controversy. However, they like a very specific type of controversy, and he referred to it as the church mom issues. So imagine Justice Barrett at church, and is it something her friends at church were offended about? Trans issues, social issues, those, abortion. So they're not scared of controversy, but church moms don't like guns, So,
I find that very amusing as a church gal. That is hilarious.
I'm thinking about it, and I'm like, that's actually that fits the pattern of what this court likes to do very much. If you run it into that framework.
Kostas brings up a good point. They have gotten into some controversial issues. I'll give you 2 right now. First of all, we just had Louisiana versus Calais come out last week. Now, a lot of people are sitting there saying it absolutely gutted the Voting Right Act, and it basically removed Section 2 of the Voting Right Act. Not true at all. Read the opinion. You'll see what's going on. There was the Scarametti case and the Mahmoud case last term that dealt with trans issues at the educational setting. Very controversial. They weighed in on that. So they are willing to weigh in on controversy, just not involving controversy.
I was actually surprised the Louisiana case came out this early. That's the classic example of a classic example of the last week of the term sort of case, but they got it out fast. So that's unusual.
It's an open invitation for everybody to redraw their lines, and maybe it was that on purpose. I don't know.
Could be. I mean, Wolford isn't out. I think Wolford is. It's hard to predict, but I think Wolford's probably coming this month and not in June, just because I don't see that as a controversial case.
I don't see it as a controversial one either.
Yeah. So,
the other one that's probably they're waiting on is Trump v. Barbara, whatever, however you pronounce it, which is the birthright citizenship case. And I actually did a couple of videos on it. I actually geeked out on that issue a whole lot. I get that the issue itself is a little controversial. I don't think the ruling of the court's going to
it's not going to be controversial. However, I think I sympathize with people like Amy Swear and others who've written about it. I think they're probably right, but there's no way the Supreme Court's going to side with them. I think the Supreme Court's going to.
They're probably right in the sense that the 14th Amendment, the reason that we created it and how it's being used now, are diametrically opposed.
Yeah, it would just be too disruptive for Chief Justice Roberts to side with that, so he's going to vote to preserve the current interpretation of birthright citizenship. However, even though it'll probably be like a 7-2 or 8-1 ruling, it's going to be a lengthy historical discussion on both sides. I think the dissenters as well. So I think that one will take towards the end, not because of controversy, but just because it's a lot of work, to go through all that. Yeah.
Well, I have a tendency to agree with Amy Swear that we should have a serious soul searching about the application of the 14th Amendment in the 21st century. I wholeheartedly agree with her. My big beef, and it is a big beef, is I don't think we get to change the applicability of constitutional amendments through executive orders.
Oh
So
yeah, yeah, and maybe if
100%.
if it did come out quickly, it would be that they would say
Yeah.
we're not going to discuss the history. We're just going to say this order was.
Can't do it. Yeah, I mean,
this
I could
order
write
was-
that
yeah.
one. I could write that one on a cocktail napkin.
Yeah, yeah,
Dear
yeah.
Mr. President, you can't do this.
And I thought maybe that's the way they were leaning until oral argument, though, when they got really into the
He
substance.
did get into it.
Yeah, because if oral argument had focused all on the order or on the executive order, then that would have been what we were getting. But I think
mean,
maybe
if I
they
was
have
a
some
justice
appetite.
there, that
to
would
go
have been
further.
my question. It was like, can you tell me one other time in the history of this country that a president has changed the applicability of a constitutional amendment through executive order? And when they sat there and went, I would have been like, I don't have any other questions for the rest of oral argument.
Well, remember at the end of Biden's presidency when he tried to declare a constitutional amendment by order?
Yeah, well,
he didn't do that, didn't he?
That
Yeah.
was at Bernie's though, so come on, give the old man
Bless his heart. I don't know. Do y'all think Amy Coney Barrett should recuse herself from that one?
Which one?
The birthright citizenship.
No, come on. I don't think that's at that point it starts to get silly with because they all have various personal interests. But I get why you say that, but no, I don't think she would, and I don't think it's necessarily called for.
I don't have a dog in that fight. I was just curious.
Also, I think we'd need her vote if
We do need her vote, yeah.
very well may be. You guys remember talking about this case? This is Johnson versus New York. Johnson was denied a concealed carry license, then caught carrying a firearm without his concealed carry license because he could not have passed through the good moral character grounds that New York had at one time, since removed by Bruin. He is challenging this. Letitia James tried to basically say, this is no big deal. Don't worry about it. They made her file a brief. She finally got her brief in back on April 29th. I'm going to check it out this week and try to get a video out about it. This is an interesting thing that likely I can't see it being accepted, but let me ask you, could you see a GVR on a case like this with just attaching Bruin to it?
Oh, for sure.
Mm-hmm. Yeah.
So-
You think so too?
Yeah, it's definitely possible.
I think they could also GVR it with, let's say that you've got Wolford and Hamani. I think, so Wolford, we agree, is not going to plow any new ground. It's just going to reiterate with the plain holding of the Second Amendment. I think they could possibly GVR it in light of that as well.
Okay. All right. Here's another interesting petition I found, United States versus Cokerham. And this kind of follows on the case that got rejected last week. We didn't talk about it last week. And then Hannah and I did a little geeking out on it when I was in South Carolina. It's United States versus Doucette. This is a person that was was basically cultivating and selling weed. But the United States had lost that case before the Fifth Circuit on an as-applied challenge to a 922 G1, came before the United States Supreme Court. They rejected the United States petition. Cokerham comes out of the Fifth Circuit in the exact same spot. Same type of case, same type of analysis, same type of result. United States is the petitioner. Here's the question I got, Kostas, is after the United States filed its opening petition, the Cokerham filed for an extension of time. Why didn't he just file a motion to waive a reply? Knowing
Because
that Doucette had already been rejected. Could he at least tried that?
He could have, and sometimes you see that, but I think maybe the lawyers just want to have their say sometimes. It's about not leaving anything to chance. You can argue it both ways. The other side is it's a show of confidence to waive your right to reply, because if they want to hear from you, they will. They'll ask
That's
you.
right. They'll make you.
Yeah. So they so I guess, or maybe they think they will get a response because it's the government. I don't know. But I personally would have waived the response, but I can't. I don't know the case well enough to speculate of why the lawyers did what they did there.
Cokerham, actually, I remember now, Cokerham has his conviction is for failure to pay child support.
Yeah.
Not a fan of that, but definitely not a violent offense.
Right.
No.
All right.
Yeah.
National Shooting Sports Foundation versus Letitia James. This is a case that challenges all of these statutory workarounds that states are coming up with to get around the PLCAA. And Kostas, you and I have talked about California Assembly Bill 1127 and all the crap associated with that. That has gotten one of the largest wholesalers of firearm parts. RMR is the name of them. And they have recently sent letters to everybody in Washington, Connecticut, Massachusetts, New York, New Jersey, Illinois, and California that they will no longer be shipping any parts to any of those states.
Will they be shipping parts to their police departments?
But just to give you an example, one FFL that I talked to here in Washington State buys $4 million worth of parts from them annually.
Yeah.
So this is a big deal.
So there's this this AB 1127 has caused this thing where there's a lot of anger on like Reddit at companies. So like on Cal Guns and everywhere else, they'll be like, why are the, because there is a way around 1127. You have to have the people submit their ID and then signature upon delivery, and so there is a way around it, and a handful of companies have implemented systems where they can still send to California customers by jumping through that. But a lot of others, especially small companies, they don't know how to figure that out. They're just intimidated because they see California is just suing my friend Matt LaRossi and others across the country, for 3D printed files posted online. So I'm not saying that's related, but what I'm saying is they see California doing these crazy lawsuits, so they just decide, whoa, we're just not going to get in this. And I think people need to realize that you can't be mad at companies for not trying to navigate this anymore, and you have to vote differently or get them out of office. And unfortunately, people ask why we haven't sued, and why we haven't sued is because of the Ninth Circuit's meaningful constraint language. Because with that in place, if we sue, the Ninth Circuit judge would just say, well, you can go to a gun store and buy these parts. You're not meaningfully constrained. You can still get this stuff. So that's why a lawsuit, until that standard changes, would be pointless. It's just a mess right now with AB 1127. I experienced it myself.
It is a mess.
I had on my new gun, I made a rookie mistake and accidentally bent my optics plate, and I needed a new optics plate to replace that one. And it's like a $20 part. And I go on the website and Fusion Firearms is like, sorry, we can't ship to California. So I either had to arrange it with the dealer, but eventually what we figured out, I called up Fusion and they treated it as a repair, because even though it was my fault and I wanted to pay them, I'm like, let me pay you. I screwed up. They're like, no, we'll treat this as a warranty repair. And in that case, we can send it to you. So they did. But the point is, like, that's the sort of garbage people in California know.
Well, let me ask both of you guys this, though. If we get to the point where we're going to preclude parts from being sent to states, and these are friction instruments, all firearms are friction instruments, and parts wear down, barrels all wear down, and now it's time for a replacement, and you have the right to have your firearm in proper working order. If you can't get a replacement, the firearm falls into disrepair. Is that an unconstitutional takings at that point?
They won't say it is. The takings clause has been so narrowed. But, the problem with that case is generally, if you do the work, you can get the parts. You have to ship them to an FFL, or you have to find a vendor that will go through the process to send it to you directly. But it's not a total block in most cases. Now, if you have, it's possible though, if you have some obscure company or smaller company and they're the only possible source and they just won't ship, then yeah, you might have a problem. If you have if
unique proprietary part,
if Fusion Firearms, for example, because they're a niche gun maker, they're very good. But if they had not sent me that optics plate, or if they wouldn't send it to the dealer or something, then I would just be out of luck. I'd have to drive to Florida to get it or something, So it's a problem for sure.
So here's one of the things I learned in talking to these wholesalers, and I want people to be aware of this around the country, because I'm sure it's not unique to Washington. One of the wholesalers told me that, hey, listen, even if we could turn around and do business in Washington, we still couldn't make money because the state sends us so many frivolous discovery demands asking for all of this data on things that we have spent millions of dollars in man hours complying with their discovery demands.
Mm-hmm.
So these statutes are being passed not so much to protect the citizens, but to give these attorney generals just a way to shake down these gun manufacturers to the point where they don't want to do business. It's almost like reverse extortion in a way. It's like a RICO activity.
Yeah, it's become preposterous.
You've seen that a lot in Colorado too. Just the number of bills chipping away at the right to do business, which, by the way, is different. You've got a right to buy a gun. You've got a Second Amendment right to acquire a gun, but the right to sell a gun is not treated the same way. It's a very different argument, and they have been very clever at the way they've chipped away at the firearms industry. I mean, it's on its way out. It's not going to last much longer. Certainly, the smaller ones are going to be forced to shut down here very soon from a variety of laws like this. And at the end of the day, like Kostas said earlier, I mean, elections do have consequences.
Yes,
You
they do.
can't blame the firearms companies for saying, it's too difficult, it's too risky, it's too expensive to do business in this state.
Yep.
Well, I
it's a
think
real- it's a real problem.
once the filibuster inevitably gets gutted, once Democrats are back in power, when it's our turn again, what we need is a much broader new PLCAA that just preempts all this nonsense from states and says, nope, you can't interfere with interstate commerce and firearms. I'd preempt state assault weapons bans. I'd preempt all of that, handgun rosters, taxes, because once the filibuster's gone, which it will be eventually, then you can do all that. That's the positive side of Democrats eventually killing the filibusters once it's our turn again, assuming we're ever allowed to win an election after that.
Yeah,
but
I get all that. I actually agree with that. I think the Democrats next time they're back in power are in fact going to nuke the filibuster, and I also agree with Kostas that has said that if the Republicans are going to do it, we should have done it 2 years ago. Now it's a little too late.
No, I wouldn't do it now. I would not do it now. At this point, let them take the political hit for it because there's not enough benefit to do it now.
Go ahead, Hannah.
As a general rule, I'm against making it easier for government to do anything. So I would probably just keep the filibuster for all time.
Don't get me wrong. So we're getting off topic now, but to clarify, my support for killing the filibuster a year ago to whenever it was because the Democrats had ran on killing it. So my proposal was it's dead anyway, so we may as well pass our stuff, but at the same time offer a constitutional amendment to them saying we're going to pass everything we want, but you can stop us by supporting a constitutional amendment to make the filibuster permanent, so you can't mess with it next time you're in power. But that was contingent on them doing it last year. Now the midterms are this November. What's the point? There's no reason to do it now.
And back to your earlier point, if the Dems do it, then obviously we should be just as eager to use that when it's our time. But Republicans never have the fire in the belly to get our stuff done when we have the chance that the Democrats do.
Well, once the filibuster's gone, their excuse for not getting stuff done is out.
Yeah, that's true. Their big excuse will go away.
Yeah.
And then we might realize how lazy they really are.
Yeah.
They've never needed an excuse to sit on their laurels and share power or do whatever it is that they usually do.
Oh, yeah. Hey, a couple other quick things. For those of you who are pot smokers, or for those of you who are 18, 19, or 20 years old, or in a perfect world, you're a 19-year-old pot smoker, hey, we got some cases for you. The cannabis cases, there are 3 that are being held right now: Harris, Sam, and Nyandaro. And we are obviously waiting for a Hamani to come out on those. And then there is the 18 to 20-year-olds. We got 5 cases there. Those are also being held. Interesting that those are being held, but all the 922G1 cases have been kicked out. But obviously, they believe that one of these 2 cases coming out is going to have some instructive value on 18, 19, and 20-year-olds. What do you guys have to say about that latter category? I get with the first issue on the cannabis issue, because we do got a case directly on point. What is the 18, 19, and 20-year-olds cases being held on here?
Your guess is as good as ours, Bill, because those have been held since.
I was having a hard time connecting the dots.
I think we've talked about this before, but like those have been held since, like, one of them's a SAF case, maybe 2 of them. I need to check, but they've been held since like October or November. There's like dust all over those cases. They've been being and I've been saying since then, I have no idea. Yeah, Hamani is a case about who can have firearms, but it's like on the other side of the spectrum from the age cases, So unless they're going to give us some really broad rule in Hamani, which wasn't my impression from oral argument, then I don't understand what they're holding these for.
You have a couple of really interesting dynamics with these that I think, for one thing, you've got a circuit split.
Mm-hmm.
And you don't really have that on anything else. And you've got the DOJ signaling that they really don't want the Supreme Court to take this issue. Those 2 things make it a very difficult. They've taken the easy way out away from the Supreme Court. So you can't easily just dismiss it because it's a circuit split, but you can't easily take it because the DOJ obviously doesn't want us to, and that matters to this court. So my suspicion, my theory for lack of any other indicator, is they don't know what to do.
Yeah.
They don't know what to do. They'll GVR it back, hopefully confuse the lower courts, and it will have to percolate for a couple more years so they don't have to deal with it for a while. Maybe that's what they're trying to do. I don't know. I just found it to be interesting, especially with all those 922 G1 cases being led to the slaughterhouse, because literally almost the only one that got accepted was Beard. But remember, it was accepted on the limited issue that had to do with the sentencing guidelines. It had nothing to do with 922 G1.
Well,
Right.
the Supreme Court usually has a much easier time processing and reaching a decision on the criminal side of the Second Amendment. They have a very difficult time taking any action on the law-abiding citizen side of the question.
Well, here's the last case I want to talk to you guys about. And this is positive news, I think. And this is a case that's captured the attention of the entire Second Amendment community. Adamiak versus the United States, State Adamiak, Navy veteran, been absolutely run through the ringer. My understanding, Kostas, I hear SAF is going to weigh in with an amicus on that.
Yeah, we're filing one today, but I got concerning news about that last night, which is that it got, maybe you're about to cover this, it got set for conference for May 14th, which is, we're filing our brief early, but amicus briefs aren't due till May 16th. So
Yeah.
why is it being set for conference? But apparently that's normal. Somebody told me on Twitter. I've never seen it before. I in my experience,
I have seen it a few times this year. I have seen it.
All right, so I guess I've
set
just never
real quick, and then all of a sudden it's like, oh no, wait a second. We still need to hear from some other sides. So okay, SAF's in on it. Hannah, I understand NAGR's jumping in on it also.
Yes, and we had that same moment of panic. Kostas just described.
No, it was Charles
no.
Nichols again. He posted last night. He posted some article saying, and none of the gun groups filed briefs. I'm like, holy shit, did I miss a deadline? Like, we're filing this tomorrow. And it turns out, no, it's just this weird scenario. He was wrong. It was just this weird scenario where they set the conference super quick because the waiver got filed right away. So I'm not sure what good news you might be seeing, Bill, but I'm not hopeful right now.
No, I'm not. I wasn't hopeful about the petition at all. I think that, well, first of all, I interrupted Hannah. Hannah, you guys are jumping in on it.
We are, and we're hoping to have ours filed within about a week. We're about a week behind you, Kostas.
And you got,
I had to check
some
with the lawyers.
really cool partners that have joined you on the amicus brief too.
Yes, I'm not sure if we can announce that just yet.
I'm excited to see it.
We have some good stuff coming. Yeah,
we do a very unique partnership that I was able to sit in on some of the strategy sessions. So, and I like where the attorneys are going. So yeah, we'll keep the partnership secret until we know we can actually discuss it. But I am really glad to see this, and I do want to see as much attention brought to this case as humanly possible, because, and Kostas and I have talked about this off the record, I don't know if an appeal is going to be the way to save this kid, but a pardon would. And that's what we're probably looking for.
It's ridiculous he hasn't gotten it already.
I agree, especially with some of the, pardon my language here, Hannah, but you see some of the other shitbirds that have gotten pardons already, and then you look at this kid and what the allegations are of this kid and the fact that he doesn't have a pardon yet. And I don't even know if Trump pardoned him tomorrow. I mean, is it even a newsworthy story on MSNBC? I mean, is it really? It's not that. It's not like you're pardoning some, pedophile or something like that.
Well, it's not like you're pardoning Blagojevich, which he has in fact done.
Yep.
I mean, it could be. It's a crappy case, and I would hate if this is the situation, but it could be that DOJ is considering a pardon, but wants to preserve this precedent. They like having their expansive powers. So like, oh, just wait until the mandate issues, and it's denied cert mandate issues. So we have the precedent locked in, and then we'll pardon him, because they like to have their expansive powers over people. That's the best case scenario I can think of right now for why he hasn't gotten one yet, is they're going to give one to him, but they want to preserve this precedent too.
Well, having amicus briefs supporting from the gun community, raising the urgency of the matter, saying this is important to us and y'all need to do something about it. I'm hopeful, fingers crossed, that matters and that makes a difference.
Yeah. We'll see.
Well, and I'm hopeful that all of the large 2A groups get involved in this. If anything, just again, to bring attention to it. I am super thrilled to hear that SAF and NAGR are hopping in. I know NAGR's got a couple of partners that we'll be excited to talk about when that brief is filed. Hannah, you're looking about a week on that?
About a week, yep.
Yeah, that's what I remember from the conversation. Okay. Well, guys, here's the good news. We are not back until Monday, May 18th. May 18th, by the way, when you're a Washington State kid, is a big day. Do you all know why? You live in Washington State. May 18th is a big day because you can. Everyone who's my age or a little older, we can all remember where we were on Sunday morning, May 18th at 8:32 in the morning. You want to know why?
Was there a volcano or something?
Mount St. Helens blew up.
Yeah.
That day. Yep.
Oh, right.
And for my home where I grew up in South King County, we heard it. We heard it blow up, and then within a couple minutes you could see it. So that was a big day when you were a kid here. You know, have a mountain blow up on you.
It'd be nice if I get a leak that they're going to deny Duncan that day. I'm just going to fly over to Washington and pray the volcano erupts.
Just throw yourself into the crater like a self-shooting.
Let's just be done with it.
You know, Kostas, I mean, if you had to do it, there's probably more glorious ways to go than just throwing yourself into the crater of Mount St. Helens. But
I don't know, it seems as good a way.
Listen, White Pass down there, it's beautiful. You know, you'll like it. So, well, you know, but if we go back and we look at the conferences, guys, we are running out of time here.
This is our last break, huh? After this, it's just a sprint to the end.
A sprint to the finish line. Exactly. And listen, I appreciate you guys being here. If ever you just don't want to be here because you're getting sick of it, or you got stuff going on, just let me know. I'm stuck being here. I just so much like having both of you here with me. So thank you for joining us.
I know if I take 1 week off,
you'll
be
the one.
Yeah.
Oh, yeah. Same.
Yeah.
And besides, there's no relaxing for either of us as long as they're releasing an order list. So we might as well.
Yeah,
might as well do it.
I appreciate it very much, guys. Okay, now listen, we're not going to talk about Benson versus the United States. Today will be the first week that we're not going to talk about that. We'll see how that goes. Closing thoughts from both of you. I'll start with Hannah. Hannah.
One more thing to point out, and that is,
please.
as of now, they do not have ruling releases scheduled at all in the month of May.
Oh, they'll schedule them. So sometimes they'll even announce.
The question is, how long do we wait for them to start adding those days?
I don't know. Sometimes they'll even say, I've seen times where it'll be a Tuesday and they'll say opinions are coming Thursday or Friday. You know, like they'll do it a couple days ahead of time sometimes. So I wouldn't be surprised if we have opinions this week, you know, even though it's not on the schedule.
So basically we're on Wolford watch and just keep a close eye on it because it can happen at any time.
We got Wolford and we got Hamani both out there right now.
I imagine Hamani will be in June just because it was later. Yeah,
I agree. It was later.
Yeah. And it's probably a more complicated case than Wolford.
Depending on what they do with the Bruin Standard in Wolford. They're not plowing any new ground on the issue itself. But do we think they'll do what they did in Rahimi or worse? I don't know. So
I don't know. I don't think we're getting anything Rahimi like this time. We'll see, though. I could be wrong. We'll see.
I sure hope not.
Kostas, I got something for you real quick, and then I'll give you some final thoughts. I happened to take a look at that case out of the Fifth Circuit on machine guns.
Yeah.
Right? A denial of an en banc review by a vote of 10-7, and everyone out in Exosphere was sitting there going, "Oh, look at this! The Fifth Circuit's basically saying they're going to legalize machine guns if they get the right case." I was like, wow, I got to check that out. So I checked it out. I did not come to that opinion.
I did. Why do you disagree?
I think that the opinion was more about that they have some precedent that they need to look at. And they thought it was very critical of the United States Supreme Court for not providing enough guidance on the dangerous and unusual component. I don't know if they were really telegraphing that they are willing to strike down 922-0. What's your thoughts on that?
I read it as they are willing to strike down 922-0 because they had 7 votes to grant cert, 10 against, but 2 of those 10, which would have made a majority, said, actually, we should look at Hollis again, and 922-0 is questionable, and we would grant cert, or not grant cert, we would grant en banc in the right case. And they just felt that this guy had waived some arguments. So I read it
the right case, but as they pointed out in there that, hey, listen, the challenge to 922-0 is possession of automatic weapons. And when we take a look at what they're challenging here, we don't know if they're talking about handheld automatic weapons or the type that we're mounting on Cobra helicopters and A-10 Warthogs and things such as that.
Right, that was the facial bit, which I thought was,
Right.
I think I criticized as a bit silly. But yeah, so with the right as applied challenge, that could come along. I think the bigger thing is, and I think I said this on Twitter too, which is I don't think there's any chance in hell that the Fifth Circuit thinks the Supreme Court would agree with them that the machine gun ban's unconstitutional. What I read this as was a threat to the Supreme Court that you better grant a hardware case soon, or we're going to shove a machine gun case up your what, like, and they'll force them.
Oh, you did get that impression that I came away with, which is they were really trying to force the hand of the Supreme Court.
Yes, yeah, that's how I read it, because I don't think there's in a million years, if the Supreme Court struck down the machine gun ban, I think they know that the Supreme Court would step in and reverse it. But what that would do, it would force the Supreme Court to finally do a hardware case. It's not under the circumstances we love, but I think I was arguing with Hannah about this, actually, was that she's a little more pessimistic, but I see it as, a lot of people think Mark Smith's on this train too. It's like, you don't want the Supreme Court to do a machine gun case because then they'll screw us over on semi-automatic bans because the language will be so tough for us. But I see it differently. I see it as, well, if they do a machine gun case, they'll write it in a way that protects semi-autos and we'll have our hardware standard. And if they wrote a machine gun opinion such that it would damage us on an assault weapons case, that would mean they were never on our side in the first place, because they know we are looking for this issue. They know people want clarity on a hardware case. So if they took a machine gun case and screwed us over with it, we were already in trouble anyway. So I'm not worried about it. I think if the Supreme Court doesn't want a machine gun case, they should grant Duncan, grant or any of these cases and resolve it. And then in that case, you can explain why, in a footnote, why you can ban machine guns, even though there's no historical support for that, but whatever, like, right. But I'm a big fan of the Fifth Circuit. If the Supreme Court denies everything again, I'm a big fan of forcing them to do a hardware case, because we're done. We need to know what the hardware standard is. Enough.
Thank you. That is true. That is true. All right. Well, with that, do you have any other last minute thoughts before I let you guys go for the day?
No.
Hannah, you guys got a busy day over there at NAGR?
But we will take the break. It does make my life a little bit easier that we're not looking for anything.
I don't have to talk to Bill and Kostas this morning. Thank God.
Yeah.
I do want to point out just one thing from that concurrence. Judge Ho on the Fifth Circuit that was basically saying we shouldn't make our rulings out of fear. We should not let fear govern what we do on the Second Amendment. And I'm such a big fan of his. He's amazing.
That's an excellent point. That's a good place to end it. So listen, for those of you who tuned in, thank you very much. It's a big nothing burger once again. We are not back next Monday. Hallelujah. Although I love seeing Hannah and Kostas, but we will be back in 2 weeks on the 18th of May. They're doing conferences on Thursdays in May. I don't know why, but if you take a look at the calendar, they are doing conferences on Thursdays. I'm assuming the orders list is probably not coming out till Monday.
Usually that's how it works. Yeah. Unless there's a Monday holiday, then it's Tuesday.
Or Friday's the holiday. Yeah.
They did that to me one time. I had a WGL AM scheduled for Monday. They did a Thursday conference and they released the orders list the next day on Friday.
Oops.
I would have showed up for nothing burger, but fortunately Mark Smith called and told me, like, hey, Bill, don't do your thing on Monday. I'm like, what are you talking about?
Well, it would have been a nothing burger.
Yeah, it would have been a nothing burger. Everyone would have known going into it was a nothing burger already. So I would have had like 2 people tuned in for that. And one of them would have been my older sister, Heidi, who's the only one that actually watches my channel. So I got 3 sisters. 2 of them are not fans of the channel at all. At all. All right, guys. Hey, both of you have a great week. For all of you who tuned in, thank you very much. We appreciate y'all being here with us. Big Nothing Burger on our 5 usual suspects. Kostas and I are back a week from today for Behind Enemy Lines Volume 8. We will have lots to talk about. In the meantime, everyone have a fantastic work week. Be productive. Be happy. Thanks for being here, guys. I appreciate it.
Thanks for having us, Bill. Always a pleasure.